Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. Hope everybody's doing well. In this particular episode, I'd like to talk about a ruling that a federal judge just made, which has enjoined, put a temporary injunction on the practices of ICE in a very sad situation. Let me set it up first by telling you procedurally, what goes on and what's happened. Let's say that somebody is being persecuted in their home country, whatever reason, which ultimately may qualify for asylum. They can come to the United States. They know that they're going to be put into detention when they come here, but they don't need a visa, they don't need anything. They can come to the U.S. and say they are claiming asylum. They will then they should be given a credible, fair interview by an asylum officer. Now, the results of this interview does not mean they're being granted asylum. The results of the interview are twofold. One, if the officer believes that they have a credible fear of returning to their home country, and that credible fear is based on, one of the five enumerated grounds of asylum, then allowed to stay in the U.S. They are then processed, and the case is transferred to an immigration court where they have full-blown asylum hearings, where they can, submit the asylum application and, actually convention against torture and withholding of removal, and they can bring witnesses and testimony, have attorney represent them, all that stuff. And if they get asylum, then of course, a year later they can apply for the green card. And under most circumstances, somebody comes to the U.S. in this type of scenario, they're put in detention during the pendency of the credible fair interview, which that takes 5-10 days, whatever it is, depending where they are. And then if the credible fear is approved and the officer believes they in fact do have a credible fear of persecution, they are then either released on their own recognizance, or a bond is issued, upon which the bond is paid, and then they can fight their case while being essentially free in the U.S. So if the case takes 6 months, a year, 2 years, whatever it is, they just go to court, have the attorney represent them, and fight their case. Well, given that, let me now set up what has happened with a certain group of people. As many of you have heard in the news recently, there's been an influx of children and their mothers, sometimes coming at different times, from Central America, from El Salvador, Honduras, and Guatemala. Apparently, the violence there has, become like the wild, wild west, and lots and lots of persecution and so forth. And again, sometimes the kids would be coming on their own, 12, 13-year-old kids, followed by their mothers or whatever it is. Sometimes they'd come together. And there's been so many that ICE actually built an Artesia detention center. And what would happen is they put these kids and the mothers in detention, which, when they come in, that's the normal procedure, no issue there. But then they would interview them. The asylum officer would come and interview them. They would certainly find that they had credible fear. And then what would happen is where the crux of this issue is. They made a blanket policy, they being ICE, made a blanket policy that the mothers and children are not to get bond. They are not to be released. They are to fight their cases in detention. So you have these little kids and their mothers trying to escape the harm and the persecution of their home country by coming to the United States. And what does the United States do? The United States puts them basically in jail, in detention, and does not let them fight their case outside, like pretty much every other asylum, person who comes here to file for asylum, but decides to leave them all in detention. Why? There's a couple reasons. One, They were arguing that it is a mass exodus from these Central American countries, and they're basically trying to show that if more people come, that they're also going to be put in detention, and therefore they are dissuading future mothers and children from trying to do the same thing. Another thing that they were arguing is that the uh, that basically what they were arguing is that the mothers and these children pose a national security risk to the U.S. Well, as laughable as that is, the what happened is a lawsuit was brought in U.S. District Federal Court, claiming that this mandatory detention policy for people who have already been found to have credible fears of returning to their home country is unconstitutional, and the judge has just granted a preliminary injunction agreeing that it is. It doesn't mean it'll end up ultimately, but during the pendency of the merits of this lawsuit, at least, the judge has issued a stop to this practice, and that is very good news. It's good news. Realistically, it's good news internationally, because we, the United States, don't want to, have the people who are fleeing persecution in their home country think that by coming to the U.S. they're just going to be detained for 2 years and so forth. They have an opportunity to fight their case. If it's not a real asylum case, if they don't win, they'll be, sent back. So box in the door is going to be able to stay. Secondly, there was no real basis to claim that mothers and their children are national security to the United States. We have lots of other threats, but not that. So all in all, it was a pretty good decision, and thankfully for the mothers and children, they can now go to their families who are ready, willing, and able to house them at no cost to the government and fight their asylum cases. And if they win, they'll be granted residency, because we, the United States, will take people who qualify for asylum in order that they don't have to be persecuted in their home country. That is the kind of country we are. Okay, if you like the video, click likes. Go ahead, you can call my office, set up for a free consultation if you like. Okay, more on the coming videos.